This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about why a rescission of a policy applies to bus jumpers, and why after rescission an insurer may be required only to pay an innocent injured person, not a less than innocent injured person who may or may not have been injured. And this is also an indication of why one insurer should carefully avoid suing another insurer. On rare occasions, bus accidents create a temptation to passengers to claim injuries as soon as it looks like insurance may apply. When the passengers on a bus learned it was insured by West Bend Mutual Insurance Company, their injuries appeared like magic. As a result of its attempted investigation of the bus accident, West Bend moved for summary judgment, and defendant Citizens Insurance Company of the Midwest responded and filed a counter motion for summary judgment. In West Bend versus Affiliated Diagnostics of Oakland, LLC, the United States District Court for the Eastern District of Michigan on February 21, 2023, weighed the equities and resolved the dispute between the two insurers and those who claimed injuries on the bus. West Bend's amended complaint stated that multiple individuals called claimants alleged that they were involved in an automobile accident on February 3, 2020. West Bend insured Kristy's Early Childhood Development Center, Incorporated, pursuant to which West Bend undertook to insure Kristy's solely against risks associated with the childcare business. At the time of the accident, West Bend alleged that the vehicle was not being used for the child care business, was instead being used by a separate business entity, DLB Transportation LLC, which had held the vehicle out for hire to the claimants. West Bend determined that Kristy's had made material misrepresentations or concealed material facts when the policy was issued, insofar as DLB would be using the vehicle in connection with its business. West Bend sought rescission of the policy and a declaration that the policy was void ab initio, that is, from its inception. Only one defendant appeared in the matter and now remains, and that is Citizens, who is the assigned claims plan insurer for the claims arising out of the underlying accident. In its motion for summary judgment, West Bend seeks to extend rescission of the policy as to the 16 natural person defendants and certain medical providers who allegedly provided services to the natural person defendants. Now, rescission of an insurance policy as to an innocent third party under Michigan law requires a balancing of the equities so that the insurer who is rescinding the policy might still be required to pay the so-called innocent injured parties. Rescission as to innocent third parties in Michigan is not an absolute right. When two equally innocent parties are affected, the court is required in the exercise of its equitable powers to determine which blameless party should assume the loss. West Bend demonstrated that it did not have any notice or opportunity to discover the true use of the vehicle. Citizens argued that with some additional investigation, West Bend could have figured out that the bus was not being used by Kristy's in the manner indicated in the insurance policy. Citizens offered no indication of some previous malfeasance, irregularity in the application, or other information that would have made it imprudent for child care center for transporting children. An insurer has a reasonable right to expect honesty in the application for insurance. West Bend also presented additional factors that weighed in favor of rescission, and those two included: 1, West Bend urged that natural person defendants repeatedly stonewalled and thwarted West Bend's efforts to investigate their claims and alleged injuries, and that their failure to participate in the litigation resulted in a substantial increase in time and costs for West Bend to prosecute the case. Because there was no evidence that West Bend engaged in any wrongdoing in connection with the natural person defendants' claims, West Bend urged that the natural person defendants' conduct in pursuing their claims also weighs in favor of rescission. In particular, the natural person defendants refused to appear for examination under oath, and 6 individuals refused to appear for depositions in a related state court lawsuit. 2, West Bend urged that although natural person defendants did not directly cause the accident, testimony was offered that the natural person defendants acted as though they were injured only after a police officer entered the bus. The bus passengers' refusal to participate in the litigation regarding rescission of the policy as against them suggests either ambivalence or acquiescence of the relief sought by West Bend. The court assumed that both West Bend and the bus passengers were innocent with regard to the perpetration of the fraud, but the passengers' conduct immediately following the accident and during the course of the litigation is not entirely blameless, and tipped the scales in favor of rescission, and the court was persuaded that the 2 additional considerations offered by West Bend regarding the bus passengers' conduct following the accident shed further light onto the true innocence of the parties. The defrauded insurer bears the burden of establishing that rescission is warranted, and West Bend did so. Given the availability of benefits through the assigned claims program and the bus passengers' conduct after the accident, which has had the effect of obscuring and complicating the litigation related to processing of their claims, the court found the equities favor rescission of the policy as to the natural persons and the provider defendants. West Bend's motion for summary judgment was therefore granted. In my opinion, it was clear that the insured lied on the application and rescission was appropriate. Whether the injured and the insurer who paid their no-fault benefits, innocent of the misrepresentation, were entitled to recover was a decision that the court had to make as to which was more equitable. The default and refusal to submit to an examination under oath placed the equities in favor of West Bend, who had been defrauded, and the 14 to 16 people on the bus who claimed injuries only after a police officer arrived made the case a classic bus jumping case that protected West Bend even though they were already on the bus and didn't have to jump on after the accident. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog, where you can subscribe to the blog and receive notice of each blog postings, usually 5 a week, sometimes 6. And you can also subscribe to the video at rumble.com or youtube.com. If you found this video and the blog posting to be interesting or useful to you, please tell your friends and colleagues so that they can also subscribe to the blog or to the videos. And you might also wish to consider subscribing for a small fee to my locals community and my Substack publications. Thank you for your attention.